Many of the January 6 defendants received a charge under the Obstruction statute, stating that they obstructed an official proceeding. Right now, the Supreme Court is debating the issue with the Solicitor General, and oh boy, it's getting interesting. The conservative justices ain't playing no games, basically saying the far left comes in, storms into these courtrooms, screams, yells, and disrupts proceedings. People pull fire alarms, shutting down the vote. How are they not getting charged? And of course, the Solicitor General, trying to defend the two-tiered system of justice that exists, can't muster up anything sane. This is wild. Many people believe that when the Supreme Court rules on this, they will likely strike down the use of this obstruction law, and it will effectively exonerate. I don't even know if exonerate is the right word. It's a wrong charge. Many people have the charges completely removed. Some, according to the New York Times, have already been freed. And I love this. They say rioters, freed rioters. Let me tell you about some of the people who were charged under the obstruction statute. How about the Q shaman? So you had people who rioted at the Capitol. Fine. Rioting's bad. You get charged for rioting. But many of the people, as most of you know, on January 6th, walked into a building with doors open, no barricades, no fences, no broken glass. That was a lie. The Young Turks, they like to lie. Cenk Uygur conceded this point. However, I'm pretty sure we brought it up when he was on the show on the Culture War. And he had claimed that I was wrong. I said, you can't charge someone with trespassing unless you warn them they're trespassing. So for many of the people on January 6th who showed up after the riot or on the other side of the building, what did they see? There's no barricades, there's no broken glass, there's open doors. And they walk in waving little American flags. And there were even cops saying, I agree with it, taking selfies, hugging people. How are you going to charge those people? Now, don't get me wrong. The people who rioted, smashed the windows, I get it, charge them. I want to stress 20 years, though? Come on. That's like a couple months, if that. You can give them a couple months plus house arrest and probation. They won't do it again. 20 years. I want to play for you some of this exchange that it's a bit long, but you really need to hear it because it is amazing. Right around the 1 minute mark of this clip, this is Millennial Other posting this, showing how the Supreme Court is not having these ridiculous arguments. I got to play this one for you. I don't know how long we have to go, but it's such a tremendous and great exchange. It's 10 minutes long. I don't know if we'll get to the full 10 minutes, but listen to this.
Relationship between C1 and C2 and make clear that C2 does not cover the conduct that's encompassed by C1. Now, I acknowledge that there were
beyond saying, okay, C1 does some things and the whole rest of the universe of obstructing, impeding, or influencing is conducted by C2. Is that a fair summary of your view?
Yes, but there was a good reason for Congress to do it this way.
No,
it traces to the statutory history.
I understand
and
that.
I would just say that...
if I might. So what does that mean for the breadth of this statute? Would a sit-in that disrupts a trial or access to a federal courthouse qualify? Would a heckler in today's audience qualify, or at the State of the Union address? Would pulling a fire alarm before a vote qualify for 20 years in federal prison?
That, of course, is Justice Neil Gorsuch saying, should Bowman, for pulling the fire alarm, taking down the warning signs, go to prison for 20 years? Of course he shouldn't. He should get removed from Congress, however, but let's continue.
There are multiple elements of the statute that I think might not be satisfied by those hypotheticals, and it relates to the point I was going to make to the Chief Justice about the breadth of this statute. The kind of built-in limitations are the things that I think would potentially suggest that many of those things wouldn't be something the government could charge or prove as 1512c2 beyond a reasonable doubt, would include the fact that the actus reus does require obstruction, which we understand to be a meaningful interference. So that means that if you have some minor disruption or delay or some minimal outburst, we don't think it falls within the actus reus to begin with.
My outbursts require the court to reconvene after the proceeding has been brought back into line, or the pulling of the fire alarm, the vote has to be rescheduled, or the protest outside of a courthouse makes it inaccessible for a period of time. are those all federal felonies subject to 20 years in prison?
So with some of them, it would be necessary to show nexus. So with respect to the protest outside the courthouse, we'd have to show that, yes, they were aiming at the proceeding.
Yeah, they were trying to stop the proceeding.
Yes, and then we'd also have to be able to prove that they acted corruptly, and this sets a stringent mens rea. It's not even just the mere intent to obstruct. We have to show that also, but we have to show that they had corrupt intent in acting in that way.
We went around that tree yesterday.
I know. I heard the argument yesterday, but I guess what I would say is that to the extent that your hypotheticals are pressing on the idea of a peaceful protest, even one that's quite disruptive, it's not clear to me that the government would be able to show that each of those protesters had corrupt intent.
So mostly peaceful protest that actually obstructs and impedes an official proceeding for an indefinite period would not be covered?
Not necessarily. We would just have to have the evidence of intent, and that's a high bar.
They intend to do it, all right.
Yes, if they intend to obstruct and we're able to show that they knew that was wrongful conduct with consciousness of wrongdoing, then yes, that's a 1512C2 offense. And
what does corruptly add, in your view?
So corruptly adds the requirement that the defendant's conduct be wrongful and committed with consciousness of wrongdoing. And this traces to the court's decision in Arthur Anderson, where the court said this is a term with deep historical roots, with a settled meaning, and that it connotes not just knowledge of your actions, which is, the intent to obstruct in this case, but further requires that it be done corruptly. And just to give you a more concrete example of how this has played out in the January 6 prosecutions, I'd point to the jury instruction in the Robertson case, which we refer to and quote in part on page 44 of our brief. There, the jury was instructed that in order to show the defendant acted corruptly, the jury had to conclude that he had an unlawful purpose or used unlawful means or both, and that he had consciousness of wrongdoing. So I think that that is an encapsulation of what the jury is asked to decide on top of the mere intent to obstruct.
Every single leftist right now should be screaming at this woman who is basically saying any protest ever is a 20-year felony charge, which is laughably insane. Well, when it comes to the sit-ins, it has to be done corruptly. Let me tell you something. This would mean that all direct action meetings for the left, you're gone. Why? Because in direct action meetings where these far left protesters plan these events, they instruct you on what to do when you get arrested, meaning you are informed beforehand. You are doing something wrong and you will go to jail. Uh-oh. Greenpeace told me it was a badge of honor to get arrested. Don't worry, they got good lawyers. This would mean that any protest ever is going to fall in line with this. Absolutely ridiculous argumenting from the U.S. Solicitor General. Now, I want to stress this. When it comes to the New York Times, they specifically mention the QAnon shaman. The charge has been used so far against more than 350 rioters, including Jacob Chansley, the so-called QAnon shaman, and members of the far-right extremist group, the Proud Boys and the Oath Keepers. I don't know that the Q shaman, as they give this example, rioted at all. I know there's video of him being escorted by police. Uh-oh, you got a problem, lady. And, I wonder if the other side argued this. As it pertains to Jacob Chansley, who was charged for obstruction. Well, videos show the police providing him guidance through the building. Certainly, he did not know he was doing anything wrong when the police actually showed him where to go and opened the door for him. You know what? Let me make sure I'm going to make sure I pull that one up, because I know there may be people on the left who are like, that never happened. You're lying. That never happened. Oh, here we go. Let me just pull up the video footage for you to make sure y'all get this one. Because here we go. New York Post, January 6th footage shows Capitol cops escorting QAnon shaman to Senate floor. All right, let's play it. Do they have the video right here? There he is. He's yelling. He's standing there. There he is, Jacob Chansley, the QAnon shaman, they call him, with his helmet or whatever. All right, are they going to play the footage? Here we go. So here's the police. Everyone's walking fairly calmly. And here's the Q shaman. Got a couple of cops taking a walk right alongside him. He's walking around. They're right behind him. I know. You say, hey, Tim, those cops are behind him. Don't worry. Keep watching. The cops come around the corner and there's a door. The police are now in front and try to open the door. Doesn't open. The Q shaman then follows the officers. This is great. He is now being given an escort with multiple police officers standing around, not a single one of them trying to stop him. He walks past all these cops. I mean, how is this guy supposed to know he's doing anything wrong? And here we are. Good sir, right this way. Please, let me show you the door. Here you are. Come on inside. No one stopped him. Thank you, Heavenly Father, for taking the inspiration needed to these police officers to allow us into the building. That's what he said. That's what he said. I just showed the video because I'm sick of this. You go to these people and say, what do you think about the cops giving the escort to the Q shaman and walking him through the building? He walks past all these cops. Nobody cares. And then he thanks them for allowing him in the building. That never happened. That never happened. He got an obstruction charge. How is this man supposed to know that anything he did was wrong? That's her argument. Let me play more from this audio because it gets better.
General, let me give you a specific example, which picks up but provides a little bit more detail with respect to one of the examples that Justice Gorsuch provided. So we've had a number of protests in the courtroom. Let's say that today, while you're arguing or Mr. Green is arguing, 5 people get up, one after the other, and they shout either keep the January 6th insurrectionists in jail or free the January 6th patriots. And as a result of this, our police officers have to remove them forcibly from the courtroom. And let's say we have to it delays the proceeding for 5 minutes. And I know that experienced advocates like you and Mr. Green are not going to be flustered by that, but, you know, in another case, an advocate might lose his or her train of thought and not provide the best argument. So would that be a violation of 1512C2?
I think it would be difficult for the government to prove that.
Why?
At the outset, we don't think that 1512C2 picks up minimal, de minimis, minor interferences. We think that the term obstruct on its face connotes a meaningful interference with the proceeding.
Well, it doesn't say, I'm sorry, C2 does not refer just to obstruct. It says obstructs, influences, or impedes.
Influences.
Impedes is something less than obstructs.
I think that this is a verb phrase where iteration was obviously afoot, and impedes is also thought of as
meaning. You're preaching the plain meaning interpretation of this provision. The plain meaning of impede in Webster's is to interfere with or get in the way of the progress of, to hold up. In the OED, it is to retard in progress or action by putting obstacles in the way. So it doesn't require obstruction. It requires the causing of delay.
And if this
so again, why wouldn't that fall within? Now, you say, well, we're not going to prosecute that. And indeed, for all the protests that have occurred in this court, the Justice Department has not charged any serious offenses, and I don't think any one of those protesters has been sentenced to even 1 day in prison. But why isn't that a violation of 1512C2?
We read the actus reus more narrowly. Now, perhaps you could look at some of the broader dictionary definitions and adopt a broader understanding of the actus reus. Still, there would be the backstop of needing to prove corrupt intent. I think that's a stringent mens rea.
Well, that's
and
not a corrupt intent. It's wrongful. Do you think it's not wrongful?
I could imagine defendants in that scenario suggesting that they thought they had some protected free speech right to protest. They might say that they weren't conscious of the fact that they weren't allowed to make that kind of brief protest in the court. And I think it's in a fundamentally different posture than if they had stormed into this courtroom, overrun the Supreme Court police, required the justices and other participants to flee for their safety, and done so with clear evidence of intent to obstruct.
Absolutely. What happened on January 6th was very, very serious, and I'm not equating this with that.
Okay, now let's just pause and I throw it back to the Jacob Chansley video where he's peacefully walking through the halls with cops everywhere. Not a single one of them tries to stop him or even tell him to leave. He then thanks the officers for letting him in, and they charged him with obstruction. Spare me.
But we need to find out what are the outer reaches of this statute under your interpretation. Let me give you another example. Yesterday, protesters blocked the Golden Gate Bridge in San Francisco and disrupted traffic in San Francisco. What if something similar to that happened all around the Capitol so that all the bridges from Virginia were blocked, and members from Virginia who needed to appear at a hearing couldn't get there or were delayed in getting there. Would that be a violation of this provision?
It sounds to me like that wouldn't satisfy the proceeding element nor the nexus requirement.
Why would it not satisfy the proceeding? Let's say they want to get to the Capitol to vote.
Well, if we had clear evidence that the purpose of the protesters who had set up the blockage somewhere, some distance away from the court, was because they had a specific proceeding in mind, maybe you have the proceeding, but still the court has required a nexus, and that's been the requirement in cases like Marinello, Aguilar, and Arthur Anderson, where the court has said it does real narrowing work, because you have to show that the natural and probable effect of the action is to obstruct. There has to be a relationship in time, causation, and logic. But Justice Alito, the other thing I would say to this set of concerns is that there are other obstruction provisions, including in 1503, 1505, the tax obstruction statute, 72.
I just want to pause and say I feel so bad for this woman because, you know, she's the U.S. Solicitor General. And so she has to argue the case for the U.S. government, but it is a losing case. Now, simply, she could say no. She could say, you are all corrupt. I will not bring false charges against these individuals, and I will stress the point, as I believe it has been proven beyond a reasonable doubt. Jacob Chansley was peacefully walking the halls. There were police all around him. In one instance, you see the cops are behind him. Later, you see the cops are in front of him and try to open a door for him. Later, you see they bring him to a room where he thanks them for letting them in the building. Now, you may argue they were just following him. He walked through what had to be like, 10 to 13 cops? Not a single one of them said, sir, you need to leave. You are not allowed to be here. Explain to me how, with all these cops around, him saying, thank you for letting me in, he's supposed to know what he is doing is corrupt or wrong. He wouldn't. That's just it. So your arguments are out the window. But I want to throw it to our good friends over at the Washington Post who couldn't help but write. Conservative justices raise examples popular in right-wing media. It's a cult. They are a cult. That's just it. Right-wing media means information that exists outside of the Washington Post. These people are deranged. They are in a cult. It is a fact, what I just showed you. It has nothing to do with being popular in right-wing media. I don't care if it's right, left, up, down, Muslim, Christian, Jewish, Buddhist, Confucianist. Don't care. Is it true? Okay. Well, as we know, the argument here from the U.S. Solicitor General is if they obstruct knowingly, knowing it is wrong, then 20 years in prison. Jacob Chansley did not know what he was doing is wrong because the police never told him not to. He walked into a public building that is normally open to the public. Now they argue the protesters who came in, or Jamal Bowman. You think Bowman didn't know it was wrong to pull the fire alarm? You're going to argue that when Jamal Bowman took the warning sign off the door and then pulled the fire alarm, he didn't know what he was doing. He didn't know it was wrong to do that. Laughably absurd. Here's what they write. Conservatives in the Supreme Court challenged Solicitor General Elizabeth B. Prelogar with a host of questions that echo right-wing media who argue that the January 6 prosecutions are partisan. Among the cases raised, pro-Palestinian protesters blocking roads across the country, Rep. Jamal Bowman pulling a fire alarm in the Capitol just before a vote, and protests against Supreme Court Justice Brett Kavanaugh's confirmation. Those examples were brought up in amicus briefs from conservative lawmakers and advocacy groups who argue that the obstruction law is being used unfairly against the right but not the left. In all those cases, Prelogar said, it would be a challenge to prove the required intent to block a specific proceeding from happening, or to prove that the disruption was extensive enough to count as obstruction. In the January 6 cases, the government has relied on social media posts and text messages where rioters described their goal of stopping the vote count from taking place. They have also emphasized that Congress was forced to evacuate the building, which has not occurred during the other protests inside the building. And I don't know if this lady actually listened to the arguments, but she simply said, proving the corruption, it was done corruptly, and that if the protesters who came in to shut down, impede, or otherwise, as the Supreme Court just has pointed out, it's not just obstruct, it says to impede. Well, they would have to just know that they were doing something wrong. Yeah. Every leftist, your protests are on the chopping block. And I'm surprised we're not seeing more from left-wing organizations to shut this one down. You're still going to get convictions in other areas for the J6ers. But this one right here means If at any point a protester has a meeting where they discuss the potential of arrest, now they are facing 20 years. And they will charge you. And they'll say to you, did you know that you could be arrested doing this? Yes. Why do you get arrested when you break the law? Is breaking the law wrong? Well, not all laws are good, but you know that the point of laws is to say you can't do this, right? The law is put in place to prevent something from happening because society as a whole has voted this thing is wrong. Sometimes laws are bad. We get that. So you knew what you were doing was in violation of the law. You knew you would be arrested, and you did it anyway. 20 years. Is that really what they want? I'd say yes. And I'll tell you why. In every communist revolution or leftist takeover, the revolutionaries are target number one. Why? Because revolutionaries start revolutions. So if the far left succeeds in overthrowing the U.S. government and they take over, what invariably happens in these circumstances is that people who gain power rapidly begin the executions of all of the leftists. Let me explain. People on the right aren't rioting. So if the left takes over, many of these cops, many of these working class people will say, I will keep my head down and mind my own business. But the revolutionaries, they're willing to throw bricks at cops. You can't have that. You can't have revolutionaries after you've already secured the revolution. Many of them have to go. So typically, this is what they do. They go after liberals and leftists first. Anyone who could foment revolution. Now, of course, people on the right get targeted in the conflict, but afterwards, people on the right now especially, they ain't doing nothing. I would not be surprised if that's the goal of these corrupt uniparty establishment elites. This will allow them to go after the far left. Why? Well, they love Israel. The far left doesn't. They are a thorn in the side of the establishment Democrats, and the Democrats need to do something about it. But you reap what you sow, leftists. I hope you're ready for this one. Anyway, this has been amazing, and it looks like it's going to get struck down. Many of these J6s will have the charges removed. Many could be released. We'll see. Next segment's coming up at 4 p.m. on this channel. Thanks for hanging out, and I'll see you all then.